Council at the Indian Subcontinent, Suez, Ms. Judith Feldner, partner, ENH, I'm sorry, I can't pronounce that name, Austria, and Ms. Himangini Dadwal, partner, AZB and Partners. So requesting everyone to please get settled now. Once again, a humble reminder to place your phones in a silent mode, and without any ado, handing it over to Ms. Anisha Chand. Before that, we'd also like to, of course, welcome Mr. Manish Mohan Govil. I'm going to request the moderator, Ms. Chand, to please present a plant sapling on behalf of ASSOCHAM to Shri Manish Mohan Govil and welcome him. Thank you.
So very good afternoon to everyone here. And after this interesting session that we had on the upcoming reforms on the behavioral aspects of the law, it is time to jump onto the transactional side of competition law enforcement. And I'm also conscious of time. We are already running late and I don't want to hold up the lunchtime for anyone. So I'm going to just ask Mr. Govil to probably say a few things, have a few opening remarks to set the stage for the discussion today. He needs no introduction. There are a lot of practitioners out here who know him very well and who deal with him on a day in and a day out basis. But for the people who don't know about him enough, he's at the helm of merger control affairs and he's the advisor at the combination division of the commission, and he's been around for over 4 years. So without further ado, I'm going to just request Mr. Govil to sort of initiate and commence this session and set the stage for us for further deliberations. So
thank you, Anisha. I think I'll go to the stage. I've just get my opening. So, good afternoon, ladies and gentlemen. We have with us Mr. Bankar, respected Mr. Bankar, who was a former secretary at CCI and later then the member at CCI and one of the pioneers in competition law and setting up CCI. Mr. Manas Kumar Chaudhary, Karan, organizers, my dear colleagues from CCI, ladies and gentlemen, it gives me immense pleasure to be part of this international community of competition stakeholders today. And I must compliment ASSOCHAM for organizing this conference. In this panel discussion, we will be deliberating on a very topical contemporary issue of M&A and the competition bill, 2 steps forward. As we are all aware that the Competition Amendment Bill has ushered in a spate of reforms and amendments. In the previous session, we have already discussed some of these like settlement and commitments. And in this session, we will be discussing about the contours of amendments in the merger review system. So let me at the outset just tell you what are these reforms. I would try and categorize these reforms in 3 broad categories. The first category are the ones that are ushering new reforms to address either a changing and dynamic market reality or certain gaps, enforcement gaps or facilitation gaps, which were there in the market. So the first one is the amendment that proposes to introduce the deal value threshold. This criteria is in addition to the asset and turnover criteria, and this is primarily to address the issue of changing dynamic digital markets and the new form of business processes that these firms have introduced. The targets which have got the targets of these companies are asset light and their turnover is also less. And their value is more derived from the data access, from networking effects, and from users, number of users. So once these thresholds are introduced, the Commission will be able to look at those deals which are which were currently escaping the jurisdiction of the Commission. Another amendment which has been introduced in this Act has been the exemption from standstill obligation of stock market purchases. In the past, stock market purchases created regulatory hurdles for business and resulted in gun jumping. The proposed amendment allows the acquirer to file a subsequent notice for stock market purchases with the condition that the acquirer will not exercise any rights in such shares before it receives the approval of CCI. The second category of amendments are those which will address the issue of performance. These are basically the hygiene type of amendments. So these are changes that have been incorporated in order to provide certainty and reduce the compliance burden for trade and industry. The bill has corrected certain inconsistencies and minor corrections, like replacing the word level of concentration from the word which was prior used, that is level of combination, as one of the factors of assessment in section 20, subsection 4 of the Act. So the bill has really gone into the minutest of details while taking up these amendments. And the bill also clarifies the definition of control to include the ability to exercise material influence. This has been done to bring the definition of control in line with the decisional practice of the Commission. The amendment bill widens the scope of relevant product market to include the production or supply of products and services considered substitutable by the suppliers. The bill has provisions for increased penalty for making omissions and false statements. Besides, the bill has incorporated certain features in the Act, such as removing the 30-day timeline for filing the transactions from the trigger date and incorporating the definition of other document as a trigger document for filing the combination in the Act itself. So these were hitherto amended by the notification to the Act or were administered under the regulations issued by the Commission. Further, the provisions of filing Form 3 in relation to investment made by banks and public financial institutions pursuant to covenant of a loan agreement or investment agreement have been dispensed with under the proposed bill. All these measures will provide clarity and certainty to the stakeholders and improve the overall performance of the merger review system. The third category of amendments are transformative in nature. Here, I would like to highlight the new section 6.4 and 6.5 that enshrines the principle of green channel in the Act itself. So today, Mr. Manas Kumar Chaudhary also spoke about the green channel, then subsequently the chairperson also spoke about the green channel. And there is a whole story about this green channel, that how it was introduced, how it was conceived during the CLRC discussions. And many of the stakeholders who participated in those discussions are present over here. And then the Act, under the leadership of the Honorable Chairman, Mr. Ashok Kumar Gupta, we had a lot of discussions, and then we conceived this Act and we brought it on paper. And then the regulations were issued on 15th of August, 2019. So that's the story. And since then, it has really got a lot of support from the stakeholders, especially the business community. And till date, we have around 64 green channel filings. It has been rated as one of its kind in the world and first of its kind. And it's a trust-based system. So I would say that green channel, green channel provision, which has been recognized by the amendment bill also. So this is really a transformative step in the amendment bill. The bill further, as Shekhar had discussed, that we had regulations where the parties were allowed to offer remedies. So the bill has further provisions that allow parties to offer remedies and modifications to avoid the long phase 2 investigation. Though previously these were introduced through regulation, these provisions are now proposed to be incorporated in the Act itself. We have seen that in last few years, many transactions that had prima facie concern have benefited from faster approval by voluntary offering of corrective remedies. And many of our panelists who are sitting over here in the panel will vouch for this. This has ensured that remedies were timely implemented, leading to faster market correction and entry of new players in the market. These provisions are also in the spirit of promoting a trust-based business environment and facilitating faster market corrections. Finally, the timelines for approval of transactions have been reduced from 210 days to 150 days. The Commission has, in the past itself, regulated and self-imposed upon itself strict timelines to clear combination cases. As on date, none of the case is pending before the Commission for more than 30 days. So you can go to the website and check. So there is no case which is pending which is more than 30 days. And that's a really a commendary part, I would say commendable part on the part of the Commission. So this new timelines will not only throw up a challenge upon the Commission to complete the approvals in shorter period, but also impose a sense of responsibility upon the business community and professionals to provide full and truthful information as per the forms of the notice and not to underplay or overplay any aspect of information. As the chairperson, Mr. Ashok Kumar Gupta, has mentioned, and I quote, the CCI considers the review process as trust-based process and places a high degree of reliance on information submitted in the notice. The stakeholders are welcome to benefit from the detailed notes to forms issued by the Commission in case of doubt regarding the relevance of information or form of presentation. The stakeholders can benefit from pre-filing consultations with the officers of the Commission. Recently, the Commission has issued detailed FAQs that draws extensively from the past decisional practices of the Commission. The bill has taken a transformative step towards ease of doing business and balancing the facilitation and enforcement function in the Commission. So thus, this competition assessment bill follows the philosophy of the Prime Minister, Shri Narendra Modi, to reform with intent, perform with integrity, and transform with intensity. So now I will not stand between you and the panelists. Let us start the discussion on the question, are M&A amendments under the competition bill two steps forward? So I will leave this answer to our distinguished panelists led by our moderator, Anisha Chand, a well-known and leading competition lawyer. And we have with us Ms. Neha Raj, the Joint Director at the Combination Division. So officers of our commission are really the people who are the backbone of and who do the heavy burden, carrying the heavy burden and the workload of implementing this efficient merger regime. We also have with us Mr. Prabhadra R. Jaipuria, General Counsel of Swiss. We have had a case of Swiss and Voilia, which was also considered as one of the outstanding cases in Asia-Pacific region by, I think, the ICN? CCI. C? Okay. And then we have Ms. Judith Pender, partner at ENH Resch Volte, GmbP. I'll leave it over here. She's from Austria, and I'm sure she will be sharing how the Austrian Competition Authority has implemented the deal value threshold. And finally, we have Himangini Dadwal, partner at AZB and Partners, another of very distinguished panel. So with these words, I'll thank all of you for patiently listening to me, and I'll hand over the mic to Anisha to take the discussions forward. Thank you so much.
Thank you so much, sir. You've done half my job. You have touched upon all the contours of what we're going to be discussing today, and you have beautifully, I think, summarized even the theme of the discussion of the conference today, which is the past, present, and future of competition law, by taking us through the journey and all the changes that merger review process has gone through. And all of them, I assure you, have been largely positive, and all of us sitting here today would vouch for that. And with that, I'm going to start the discussion. And let me also tell you that you can see a good mix of panelists today. And of course, we have Judith, who's from Austria, who's going to share insights and experience that she's had over the years with the deal value threshold that was introduced in Austria back in 2017. So we are really forward to hearing from her. But the idea is to provide you a more multi-dimensional view, which is why we have representatives both from the bar and the bench, as well as from the industry, so that you can go back home with a holistic perspective on what's life going to look like after the amendment bill becomes law. So, as you all know, merger review is a forward-looking evaluation in that what the enforcement authorities want to do is to look at the likely future outcomes and effects of a transaction. So what they do is really crystal ball gazing, right? And for that very reason, enforcement authorities all over the world are seeking tools that actually enable them to review transactions that perceptibly are problematic. And India is certainly no exception to that rule. In fact, I would say that India is one of the few jurisdictions which does not even have the residual power to call in transactions which on the face of it could look problematic, but they don't meet the thresholds. And this brings me to the first segment of our discussion, which is also frankly the elephant in the room. That is the deal value threshold, or the size of transaction test. What is this test? For the unversed, this test is basically a new criteria that the bill seeks to introduce. It is based on a twin criteria that needs to be met. The first of it is if a transaction meets or exceeds the deal value of more than 2,000 crores, and if a party to the transaction has substantial business operations in India, you may have to report the transaction and seek prior clearance from the CCI, and this test is in addition to the existing asset and turnover-based tests which are already enshrined in the Act. So since we have Ms. Neha Raj, who's the Joint Director at the CCI's Combination Division, I'm going to start with her to understand a little bit more about the thinking and the driving force behind introduction of the deal value threshold, and why does the CCI think that this could be the right metric for ascertaining the competitive significance of a transaction.
Thank you, Anisha. Very good afternoon to all of you. It's a pleasure to be attending this ASSOCHAM conference as a panelist, and that in physical mode after a couple of years. Coming to the question of deal value threshold. So presently in our Act, we have an asset turnover based threshold, as everyone is aware. So there have been cases which have been filtered out from the assessment of the Commission because of this threshold. Alternative have been looked at, many other alternatives, and world over many jurisdictions are looking at alternatives as to how to capture certain transactions. Mainly these transactions relate to the digital sector. These digital platforms are often marked by things like network effects, high economies of scale. As a result, they offer free or low-cost services to increase their user base, which may not translate into significant asset or turnover base. So basically, the asset turnover thresholds in such cases do not capture acquisition involving such digital platforms. So deal value threshold is one of the measure where asset turnovers are not sufficient, but the acquiring companies are ready to pay significant value for the acquisition of these firms or acquisition in these firms. Then Commission would like to look at what is the reason behind that. What is the benefit these companies are getting, and often they do because that helps them increase their user base, which in fact it translates into better turnovers for the acquiring companies, and sometimes they may gain market power out of that. So this is how the rationale behind the deal, introducing a deal value threshold. In India, presently, the competition bill says that its a deal value threshold is at 2,000 crore, which is roughly $250 million. It's then we have the target exemptions also. So basically, this is to under the target exemption, we have a 350 crore and asset and 1,000 crore target exemption threshold. So deal value threshold would be an exemption to that exemption. So it will bring in those transactions which were filtered out because of that notification and capture them for assessment. The amendment bill also says that there has to be a local nexus consideration for which the Commission will be framing the regulations in time to come. This is a very new area for us. So we'll be looking at various factors, how to look at it, how to see the deal value, whether it will be in the form of party submissions, or we have to go by fair value market methods or some other methods. We'll have to look at that. And in terms of local nexus, also a similar approach has to be seen in terms of practical necessities. So that is the idea behind deal value threshold.
Thank you, ma'am. I think there is convergence internationally that there is some sort of enforcement gap, and there are many transactions which could be problematic that's flying under the radar. And different jurisdictions are taking different sort of measures, including policy reforms like ours, to be able to address that issue. But going back to the text of the bill, Himangini, why don't you jump in here and tell us, based on the text of the bill as it stands today, is there enough guidance to compute deal value of a transaction? And I ask this especially in the face of complex deal making where monetary consideration is not really the only consideration that is attributed to a deal. So any thoughts there, Himangini?
No, thanks, Anisha. And first of all, thank you to ASSOCHAM for organizing this very timely discussion on the amendments, and really grateful to be part of this great panel. Just before jumping into the text, I feel like it's important that that this bill has been referred to the Parliamentary Standing Committee, and it's still very much under discussion, including whether the deal value threshold should be introduced as a new metric. I think the intention is always wonderful. It's great. I think there's always merit in seeing how we can do things better, but I think the devil sometimes lies in the detail. And it's great that we actually have Judith here who can speak to the Austrian experience. And because at least based, I think in 2018 when Germany introduced these, I think since then, not sure, or at least the statistics don't show whether a whole lot of killer acquisitions or commitment decisions or any of the concerning areas have been caught. So I think it's important to evaluate the empirical evidence based on the few jurisdictions. I think another indication of this being debated, and about 4 or 5, I think 4 jurisdictions currently that have adopted this. But and I think finally is one of the reasons why we've adopted this is to catch digital markets, but also the text currently is not specific to digital markets. It is sector agnostic, and I think it's important to see how that may translate into, say, asset heavy industries like, say, the infrastructure market, where maybe a 2,000 crore threshold may not be that significant, in the target, for example, would have significant turnover assets, but the deal itself may not be concerning from a competition perspective. But with those initial thoughts, out there. I think the text is also, I think, like Anisha absolutely correctly mentioned, I think the text is important, and even if this were to be introduced, I think a lot of good can come out with clear regulations. Currently, the value of transaction itself is, again, the intention is great, but how do you compute value of transaction? I think the easy answer is when there is a clear monetary amount that is set out over there, but I think we will definitely need more guidelines, for example, where you have transactions, where you have share swaps, or you have deferred payments, or performance-based payments, or belated payments over time. These aren't exactly captured at the very outset. It's important that there be some clarity, because this will be a notification assessment trigger. So, we can't afford to, to wait to see how the value of those deals will be identified. So I think guidelines are imperative. This, again, Judith, we will be looking towards you to see, how these have been clarified in, in your jurisdictions where you do have this, because I'm sure these questions have come up. But, it would be interesting to see where the guidelines are, whether one should do this on a case by case. I think, the chairman very correctly mentioned that, a case by case approach is imperative, and, I don't think anyone in this room would disagree with that. But equally, some certainty, would help the industry go a long way, because, these are the basic tenets for notification. So I think these, how to compute the deal value would be absolutely key.
No, that's right, and I agree that objectivity, and that's what Himangini was trying to say, objectivity is and certainty is very essential to determination of reportability, and for that I'm sure the industry is going to look to the CCI to provide as exhaustive guidance as possible, which I believe will happen through regulation, consultation, and also pre-filing consultations where there are gray areas, because everything cannot be predefined right in the beginning. But Judith, we've had too many references to your name now, so it's about time that you weigh in here. But I think I'm going to diverge a little bit, and I'm going to straight go on to the local nexus test that Austria has. And clearly our law or the bill seems to be very inspired from the way Austria has developed its law, and the expression that is used in India, so at least in the current iteration, is substantial business operations in India, whereas I think in Austria it is significant domestic activities. So I think we would like to hear from you on what is the kind of guidance Austria has come about in defining this very difficult and nebulous expression, and what are the kind of practical challenges that you think Austria as a regime has faced practitioners, regulators, and the business alike?
Thank you very much. So first of all, thank you for the invitation. Actually, it's very exciting to listen to all your thoughts in relation to the transaction value test, because I feel like being in 2016 when we had this discussion, and of course the discussions were the same. In Austria, finally, then the law was implemented in November 2017, and I do not remember how we managed it, but for the first 6 or 7 months, we did not have any guidance. This means we just had the law, which says, so we still have, so the transaction value test in Austria also includes still turnover thresholds, meaning worldwide combined turnover of 300 million euros, combined Austrian turnover of 15 million euros, and then 200 million euros value of consideration, and finally then the substantial activities in Austria. I think substantial activities or operations, it's the same, and also discussing it with US, UK colleagues, operations and activities is always the same. It was clear that the Austrian FCA, together with the German FCO, would publish a guidance paper. So this is no regulation. They do not have the legal power to issue a regulation, but it's only a guidance paper. But I would say when it then was adopted in July 2018, since then it's the most important paper ever issued by the Austrian Competition Authority. So this is a 30 pages paper, 50% dedicated to how to calculate the value of consideration, and the other part concerns substantial activities. Also to briefly describe the process, how this paper was then finalized. Many stakeholders were included, M&A lawyers, competition lawyers, and also other parties. The draft of this guidance paper was published in May 2018, and then we had also the possibility to comment. Actually, everybody was very impressed by the draft already, but of course everybody thought, okay, this is not covered, this is not covered. And then finally the paper was even more extensive. Since then, summer 2018, everybody, so lawyers, the authority, we thought, okay, we are very well prepared. We even managed it without that guidance paper for 6 or 7 months. But to be very honest, this was very tough. Yeah? Advising businesses on the transaction value test without such guidance paper, because the explanatory note to the draft law was like 2 paragraphs saying, we want to catch digital cases, we want to catch pharma cases, including targets with no or only little turnover. So everybody knew, okay, you have to be cautious when it comes to digital cases or when it comes to pharma cases. Now after 4 years working with the guidance paper, I would summarize that 90%, a little bit more than 90% of the cases can really be assessed, and you find also an answer to the question whether the case is notifiable or not on the basis of the guidance paper. And of course, it provides guidance in respect to what are substantial activities. Yeah? So in particular regarding R&D, I think this is a very important topic, especially in India. In Austria, it's understood maybe very broad. Let's see how this will then be the case in India, because already like a small team of researchers for a certain drug of a US company, but with a lab in Vienna, this could already be substantial activities, even though it's only 5 people. So maybe at first sight you would not think this is substantial, but in Austria they say substantial means not marginal. Yeah. So, an important request of the industry was that the guidance paper would be updated once there are cases, once there have been cases. So this is also reflected. Last year we had the first two cases, failure to notify cases in transaction value cases, and then the guidance paper has now been updated. Only 2 or 3 sentences actually, but this covers the 2 recent cases. I think if we have time, we will come to this later.
Sure. Thank you so much, Judith, for that. And I'm sure the CCI is listening, and 90% of the cases, if those are cleared through the guidance paper, I think that's a great success rate. But as the chairman said in his opening remarks this morning, the guidance has to be a living document because there is that much dynamism in all industries. So it cannot ever be frozen, and the Commission needs to have that flexibility to keep updating it, which will be beneficial both for the CCI as well as the industry. But Himangini, jumping back to you again, is there anything in the text of the bill that stands out, and maybe focus a little more on the expression that a party to the transaction needs to have substantial business operations? Do you think there are something lacking there or any pitfalls there?
Yeah, absolutely, Anisha, and I think the big elephant over there, again, I think this is where the operationalization, as the chairman mentioned, is so critical. It currently says parties have substantial business operation in India, and so it's not limited to the target. Again, that would effectively mean that if the acquirer is big enough, not even that big enough, I mean, honestly, because 2,000 crores and a global deal value will not be significant. And if substantial, if you're going to go the Austrian way, is going to be, not marginal, and you're taking a look at, the acquirer's business operations alone and not just the target. I think that may not have been the intention. So it could just be a drafting oversight. But it's important because I think the chairman also mentioned in his speech that they were also looking at it from a target perspective. So I think that's certainly a clarification we could all benefit from in the text itself.
And since the parliamentary committee is still open to discussion, I'm sure this point can be taken up, and in case this is an oversight, can be corrected, because we obviously don't want false positive, and we want substantial business operations to be read with substantial being the operative part and not having to notify global deals with an India leg simply because there is an operational India subsidiary that generates revenue. But Prabhata, why don't you come in here, and I would maybe like you to weigh in on the conversation and tell us what do you think from an industry perspective. Do you think there's going to be increased compliance burden, especially for startups, or do you think that, and just to give you a little bit of flavor, there was a discussion initially that maybe the Indian authority does not need a deal value threshold. Maybe what it needs to do is really tweak the current de minimis thresholds and achieve the same thing that it seeks to achieve by introducing a deal value threshold. So very quick comments there if you can.
Yeah, I'll try to keep it short. Mr. Chairman rightly said that it is one of the three most important changes in the bill. Similar things have been also experimented elsewhere in Austria, Germany, and in Europe also. They talked about it. There was a criticism that it will have chilling effect on innovation and investment. I don't personally agree with that point of view, but something that has to be kept in mind, that it has never been the intent of this new threshold, so it should not be creating that. Secondly, there was also a criticism that earlier that such a threshold will increase the administrative burden on CCI. Again, Mr. Chairman clarified that he doesn't foresee too many cases coming in, so we should not be bothering too much about it. It would be interesting how the regulations are framed here under, and how different, for example, for a stressed asset sale where a lot of value has been kind of taken care of by way of some haircut given by a lender, how will the deal value threshold be calculated there? Similarly, in a hostile takeover situation where we don't know who is, what value is the final deal value, how is going to be this test applied there? So these are some questions which we'll need to see, and it would be interesting to see how these regulations are framed and what nuances are brought into there.
Very interesting thoughts there, and I think good food for thought for all of us for IBC matters or distressed sale matters and hostile takeovers. I don't think any of us have the answers right now. Maybe Judith does, but I'm going to now quickly close this session. But I think Judith, everybody would, all the audience here, including myself, would like to really understand what has been the Austrian experience overall. Have you? What are the kind of sectors that were impacted? Because you did say that initially the idea was to be able to catch transactions in digital space and pharma space, but have there been any other unintended consequences of capturing transactions in other sectors? Generally, what are the number of reportable cases? Because Chairman, I think, has assuaged a lot of concerns today, and that's where even Prabhata is deriving a lot of comfort from. But just to understand a little bit more on statistics and generally the success with this novel threshold, were you really able to discover and catch and review transactions that were truly problematic and which otherwise could not have been caught under your primary thresholds?
Initially, before the law was implemented, it was it was estimated that there would be 5 additional merger filings per year. But of course, it was difficult to provide such an estimate as in Austrian merger filings. There is no obligation to provide information on deal value. So this deal value topic was completely new to the Austrian Competition Authority. So it was 5. The number was more or less 5. Finally, in the first 3 years, each year we had between 15 and 20 cases, additionally triggering a merger filing on that basis. And finally, so the maximum so far last year was 42 cases. But we have to put this into perspective. In Austria, in total, we had 650 merger filings last year. Yeah, but 42 is still a lot. Yeah. Concerning the sectors, so the Austrian FCA does not disclose all the details. But yeah, there are many pharma cases, indeed. Not that many digital cases, not clear platform cases, I would say, and a lot of software cases. Yeah, so really big US software deals with, in my view, only little Austrian nexus, because the software is distributed in Austria and there are 10 customers maybe. So yes, so, and also this was a surprise, and the legislator did not have had this in mind, was real estate projects.
No, thanks for that snapshot. And I think overall, it's also perhaps important to also undertake an empirical study to really see whether the policy reforms or the thresholds that we've introduced actually have resulted in some meaningful impact, or was it really a futile attempt? And I think we at the CCI definitely do that. But on this note, I'm going to now switch gears, look at some procedural amendments. Again, Mr. Govil has already touched upon it, so I'm not going to belabor on it too much. But as all of us, we know that the amendment seeks to reduce the approval timelines for the merger review process. We are currently have, the commission, sorry, not we, but commission has 30 working days to come up with its prima facie view to see whether a transaction needs to go into phase 2, and the outer limit timeline is 210 days. This is sought to be shrunk to 20 calendar days and 150 days. And while the intent, of course, is great, it means that you want your clearances faster, your closing should be faster. In reality, when the rubber really hits the road, how is it going to be? And Prabhada, I think I would like to hear from you from an industry perspective on what do you think about the contraction of these timelines?
So I agree with you, Anisha, completely that intentions are good. In fact, CCI has done a commendable job in addressing these applications at a really fast pace, faster than what was mandated by law. Having said that, especially in, not in friendly mergers, but especially in hostile cases, collation of data is very, very complicated, especially if it's cross-border. As an in-house counsel, as a general counsel, it falls on my desk to collate the data internally from various stakeholders. And I can tell you it's not easy, because it's not a usual request that you are making to different departments of the company, operations, business development, developers, and finance, etc. So it's difficult to explain to them, get the data in the right format, and then present it to the law firm, then having some iterations, and then sending that data back to the commission. So I think it would be helpful, even for the commission, it's tough. That kind of timeline is tough for them to act on as well, especially when, as I said, the cases are not of friendly mergers. So I would say it would be beneficial for everyone if we had gave a good second thought to this topic and came up with something which was practical. And because there is a risk of invalidation, and which squarely falls on the parties. Once we get into the process, and just because we missed some stiff timelines and then there is an invalidation, we restart the process, does it help anyone? So there is a serious need to look at it and take some corrective measures there.
Very spot on observations, Prabhada, and you're right that technically under the statute, the onus is going to be on the CCI to clear the transaction, but the parties are not entirely ring-fenced, and there could be ramifications such as high number of RFIs or invalidations that could probably be counterproductive, even though the underlying intent is great. And with that, I'm going to segue into my third segment. And the reason I'm jumping is because there's a lot to cover and there's very little time. But I'm going to talk about another amendment, which is interesting because it's an amendment that deals with inclusion of a failure for the parties to submit information pursuant to an inquiry under section 20 subsection 1 of the act, and this is actionable as per the bill under the gun jumping provision. So 43A for the uninitiated people out here is a gun jumping provision where the CCI has the ability to penalize up to 1% of the assets or turnover, whichever is higher, in case there is a failure to report a reportable transaction, or where there is partial or complete closing of a transaction before CCI approval. On the other hand, section 20 subsection 1 enables the CCI to issue probe notices to inquire into why a transaction was not notified, and it can issue that until 1 year of closing of the transaction. The question is for Neha ma'am. I think first we would like to understand why do you think this needs to be included under the provisions of 43A, given how the penalty can be very large, at least under the statute. And then Himangini, I'm going to hear from you on what you think, and if the concerns, if at all any, could have been addressed under any other existing framework or provision under the existing framework. Yeah, ma'am.
So the bill has introduced this provision whereby even if the parties don't respond to the query letter sent under section 21, which is basically a suo motu inquiry into transactions which might have been notified, which appear to be notifiable but have not been notified to the commission. So when these queries are sent, parties are required to respond. If they do not respond, then the commission had no option, in fact, if they do not respond, except saying that it's a direction of the commission to respond. I would not say no option, but it's something which we would not like to press upon. But this gives us more teeth to those 21 inquiry letters that we send. So parties are now liable if they don't respond to those queries. They can be proceeded under section 43. It's a penal provision, and penalties will be imposed. So from commission's perspective, it's giving more teeth, but then from parties' perspective, you have to see that section 43 is worded as may. So it's commission may impose, and even for the quantum, again, it's a may provision. It may go up to 1%. And if you see the practical realities, then there have been 50 odd cases under this section which the commission has decided. And penalty has largely been nominal on the parties, ranging from average, I'm saying, 5 lakhs to 1 crore. Only in exceptional cases, the commission has gone up to that maximum limit. So I think it just makes this provision more, it strengthens the provision with the commission. So that's the implication.
Himangini, any thoughts there?
No, thanks Anisha, and thanks Nia ma'am for those thoughts. But I think from a practitioner's perspective, and from when we're looking at it from a client's perspective, I think a 1% imposition, even if there's a discretionary power that has been bestowed upon the commission, and I've got to say that the commission has, of course, been very practical in its implementation. They understand the power and they use it only, in extreme cases. But I think, unfortunately, I agree with Nia ma'am, because, there is a section 43 under the Competition Act where, for non-compliance of certain directions, the commission could impose, consider initiating proceedings which could result in the imposition of penalty, but those are restricted only to certain provisions of the Act, so under section 36 or under section 41, not necessary, which doesn't include your section 20 subclause 1. So, but since we are looking at amendments to, the Competition Act, maybe, one thing to consider would be, instead of, going at the stage of 20 subclause 1, it's important to consider that the notifiability of that transaction hasn't been defined yet, or hasn't been ascertained. It's to determine whether a combination was notifiable. So if a party doesn't respond and the transaction was indeed not notifiable, to then impose a penalty that could go up to 1% of the transaction value, may not, be, entirely justified. So maybe we could look at other provisions, for example, expand maybe the scope of Section 43, which has a good due process built in, which says, parties will be given an opportunity of hearing, and, if insufficient cause, or, only when sufficient cause is shown for non-responsiveness can, penalty proceedings be initiated. So I think parties should be accountable, because I don't think non-responsiveness, to a regulator is ideal. But equally, there may be some other provisions where, one could explore in bringing compliance to the fore, rather than looking at, the 1% combined value for a transaction, which may not even ultimately be notifiable. So I think that's where, some thought maybe, or some more deliberations would be useful.
So, yeah, I mean, I tend to agree, because, I mean, the simple issue here, which according to me stands at odd, is that can you really, truly, hand on heart, equate failure to respond to a notice, which is just an inquiry, where you've not even ascertained whether the transaction is reportable, with a failure to report? And I think that's the big question. And if there is any other, maybe slightly lesser penal provision, maybe the Commission can consider that, and the Parliamentary Committee can consider that. But hopping again, switching gears to another material change, which concerns the material influence test that is sought to be introduced as the new standard of control. Neha ma'am, quickly wanted to hear, what do you think from the Commission's perspective are going to be the implications on the industry? Because we've heard the chairman also say, and we've heard CCI say on a lot of forums, that we are simply formalizing and codifying that into law. But generally speaking, any thoughts around if the Commission has considered what the real practical implications of that change is going to be?
Well, you've heard the chairman. So, material inference is something which the Commission has already stated in its orders, previous orders, and the parties and stakeholders are quite aware of material influence. There are several cases that come forward. There are combination regulations also, which address this issue in different forms. So, in terms of effect on industry or stakeholders, I think it's something which is merely a codification of what has already been the practice. I think that's about it. It's a...
Right, no. Himangini, very quickly, you will have to tell me what you think. Do you agree? Do you think differently? But it has to be a very, very quick response, because I'm getting chased to close the session ASAP.
No, fair enough. I mean, I don't think any conversation on merger control is incomplete without a conversation on material influence, so I fully understand. But, a lot has been said. I think Neha ma'am is right in the sense that there has been, this threshold is already part of the CCI's decisions on merger control, but I think it has been mostly in the context of the item minority acquisition exemption. I think one of the things that we haven't had a chance to fully appreciate is that when you're diluting the threshold of control to material influence, it also has ramifications on other aspects where control can come in. For example, computing jurisdictional thresholds on, say, group. So again, this is at the very threshold. When you're looking at exemptions, there's a subjective element. There are certain cases where you may want to catch more. But, you can't have different thresholds for, once a particular definition is included, you'll have to use that same standard wherever it's been used. So, for example, group has 3 elements. The third element is control. And this effectively would mean that when you're computing thresholds, or when you're looking at group thresholds, the parties would need to effectively look at each and every investment where they have a director or an observer, certain veto rights, and then include all of those assets and turnover in their group. So I think this would change, this would of course be administratively sort of difficult to implement, again at the notification stage. So I think a lot has been said about whether or not this test should be included from an exemption perspective, and we may not have time enough to go into that, but I think just to bring out this element would be also important to consider when finalizing these amendments.
Absolutely, I think a lot has been said about other aspects, but this is something that's sometimes we miss the trees for the woods, and this is exactly what seems to have happened. But Prabhada, very quickly, your take on the proposal on material influences being the standard of control under Competition Act.
Yeah, of course, chat aa gaya hai, to khana zaruri hai, so I'll try to keep it short. Control definition is found in almost every legislation. You see Companies Act, you see SEBI. SEBI, in fact, came up with a discussion paper on bright line test for controls a few years ago. So, in Jet Jet and Etihad deal, we saw that SEBI and CCI were taking slightly different stands on control at different stages. Finally, SEBI started following what CCI was saying, so maybe CCI was taking the correct opinion. So the point here is that it's much easier for everyone if different regulators and while drafting these legislations, if we can harmonize these definitions and come to a common definition, because these legislations have similar flavor, the intent is similar, so why can't we have a common definition or a similar definition, harmonized definition? Because when we finally go to a constitutional court, while interpreting this definition, they will look at all legislations, not just your legislation. So maybe it's good to begin with the same definition and then develop the jurisprudence around that.
No, that's always, uniformity is always ideal, but I think it's also, and divergence is not something that anybody wants to navigate, but I think the truth is that different legislations have different mandates, and therefore it is acceptable to a certain degree to have slightly varying definitions to be able to address the harm or the mandate that they have been built to address. And with that, I'm going to move to my final segment, which is absolutely non-controversial, very, very pro-business, very business-friendly, which is on, and Mr. Govil has already, once again, very kindly touched upon it. It's the standstill obligations and the derogation of standstill obligations in the context of acquisition of shares or convertible securities on the stock exchange, or the implementation of open offer. And what the proposed legislation says, proposed bill says, is that if you are free to acquire shares, you don't need prior approval of the CCI. If you're acquiring shares on the stock market, provided you come to the CCI for approval within a reasonable time, and during the pendency of CCI's approval, you're not exercising any beneficial rights or dividend rights or voting rights attached to those shares. So it's an extremely pro-business change. And I would like to hear from the horse's mouth, which is Prabhada, to tell us how this is going to benefit the industry. And then Judith, any final thoughts on, you've seen the text, if there is anything else, and the text really mimics and clones what the EU MR says about derogation of standstills in the context of stock exchange, acquisitions over the stock exchange. So any thoughts about how we can further fine-tune it or make it much more robust?
Of course, it's a welcome decision. I'd let Judith comment on the EU laws. Of course, industry would benefit from it because it brings least disruption to the business operations while the deal is going on in the background. And by the time these things settle, sometimes business disruptions cause more harm than the merger brings benefits. So it's good to have these provisions which allow business to function as usual and without any major impact on decision making. Yeah.
Sure. And I think because these are stock exchange acquisitions, it's also very easy to unwind or unscramble the egg, because you could just sell the shares back on the stock market where you bought it from. Judith?
As I know, no time is left. So in Austria, we do not have this provision, so I'm really jealous that you will now get it, as it appears. The EU has, yeah. So that's the problem. Not that's the problem. That's you're always very happy if you're working on a transaction which triggers the EU thresholds, yeah, because then one problem less, yeah. So for this reason, I would not be too demanding at this stage. I think you can be very happy with this proposal. And then after 2 or 3 years, once you have worked with this provision, maybe you can fine-tune it.
Thank you so much. So would you like to give any closing remarks, being very mindful that all of us are famished and we've been patiently listening? I would still ask Sir to probably give some closing remarks, but I really enjoyed this discussion and hope you all did too. It was very enriching, different views and different aspects of things that we heard and learned today. Over to you, sir, for any final closing remarks.
Thank you, Anisha. I think in spite of some waiting which is required, I would give some closing remarks in this case. And I agree with Anisha. It was a very, very interesting discussion we had, and some of good points have come out, especially with regard to the deal value transaction, and especially some questions regarding how we are going to calculate deal value threshold in the case of IBCs and hostile takeover. This is a question we have yet to deal with. But certainly, yeah, there are certain what you call apprehensions with the industry, especially with two stages, like how do you calculate deal value? And the second is how do you calculate India nexus? So I'm sure that in both these cases, we have already started some preparation, and we will reach out to the stakeholders and also draw from the experience of jurisdiction like Germany and Austria, who have already taken out guidance paper in this case. And we are sure to come out with some guidance, and which will bring about certainty, because that's really the motto of our competition regime, is to bring certainty and bring stability in the system, and not to leave things which on interpretations, especially at the notification stage. Also, I am sure the challenge, and as I mentioned in my opening remarks also, that the challenge of reduced timelines is very big challenge, and we need to cover both at CCI. We have to change probably the way we will have to function. We have to bring more things during the pre-filing consultation stage, and those type of guidelines have to come, because that type of interaction will definitely reduce the time that is being taken, and we would make sure that it would also ensure that not many invalidations take place, which are which unnecessarily put regulatory burden on the industry. And finally, a point of control, which was discussed. I think this point has already been made. Control is something which we are trying to codify. It's a positive measure, because it takes away the regulatory uncertainty. I think for once we will have a definite position that this is the definition of control. It is in the Act, and there are no changes over here. And finally, this provision of derogation is a very welcome step. 2 years back, 3 years back, we had also consulted with the industry. We wanted to come out with a regulation. Somehow we thought that this is already there in the Act, so we didn't move forward in that. But yes, a lot of industries are facing problems. We have to impose penalty, though we do not want to impose penalties, because they have not notified and they have jumped the gun when they buy stocks when they buy the shares on the stock exchange or through open offers. So with these words, I thank the SOCHM, the organizers, my fellow panelists, and all those who are present here. Thank you very much. Have a nice week. Thanks.
Thank you, everyone. We can proceed for lunch now, I suppose.
Well, thank you. Just a moment. I'm going to request Mr. Santosh Parashar to very quickly, on behalf of everyone here at ASSOCHAM, present a little memento to the session chair, and thank him for joining us today. Requesting everyone to please join us for lunch now. With that, we conclude this session. The break is going to be only for half an hour. We'll request everyone to kindly try and return by 2 p.m. Thank you.